to its prolonged occupation, the West Bank and East Jerusalem. Notwithstanding, the Security Council has reaffirmed that the settlements constitute, and I quote, a flagrant violation under international law, end of quote. As this court said in the Namibia case, a binding determination made by a competent organ of the United Nations to the effect that a situation is illegal cannot remain without consequence. As in that case, in answering the legal questions now referred to it, the court is not concerned with the question of what practical steps would be required to cease the occupation. France's settlements in Algeria were not only more numerous, they were also far older and better established than Israel's West Bank colonies. I come to my third point regarding systematic racial discrimination. Israel's policies and practices amount to systematic racial discrimination and apartheid. Israel has imposed a system of racial discrimination against the Palestinian people since 1967. It is a system that distinguishes deliberately and systematically along ethnic and religious lines, systematic racial discrimination and apartheid. Israel has imposed a system of racial discrimination against the Palestinian people since 1967. It is a system that distinguishes deliberately and systematically along ethnic and religious lines between the Palestinian population and Jewish Israeli settlers illegally transferred into the territory. The purpose of domination and oppression may be inferred from Israel's pattern of conduct against the Palestinians. I turn to my fourth point, Jerusalem and its holy places. The holy city of Jerusalem is unique in that it is sacred to all three Abrahamic religions. Under the historic status quo, it is the right of Christian, Jewish, and Muslim communities freely to access and worship at their holy places in the city. Ottoman decrees set out these rights in the 19th century. The regime was later confirmed in multilateral and bilateral instruments. The historic status quo has today developed into a so-called objective regime, which captures the point that it is characterized by a permanence which the instruments that established it do not themselves necessarily enjoy. Every state interested, therefore, has the right to insist upon compliance with this regime. Under Israel's prolonged occupation, Christians have not been free to access or worship in the Church of the Holy Sepulchre, and Muslims have not been free to access or worship at Haram al-Sharif and in the Al-Aqsa Mosque, to name only some prominent sites. The rights under the historic status quo must immediately be restored. This issue is of great importance to Pakistan, which is home to the second largest Muslim population in the world. And now I come to my final point of the first part of my statement. Pakistan believes that the two-state solution must be the basis for peace. In the Wall case, this court observed that the two-state solution was to be encouraged, and I quote, with a view to achieving as soon as possible, on the basis of international law, a negotiated solution to the outstanding problems and the establishment of a Palestinian state existing side by side with Israel and its other neighbors with peace and security for all in the region. End of quote. Pakistan supports this call. On 26th of October 2023, Pakistan was pleased to vote in favor of General Assembly Resolution which reaffirmed that, and I quote, "a just and lasting solution to the Israeli-Palestinian conflict can only be achieved in accordance with international law and on the basis of the two-state solution." 2 months later, on 22nd of December 2023, the Security Council reiterated its unwavering commitment to the vision of the two states, consistent with international law and relevant UN resolutions. And these and numerous other resolutions by the political organs of the United Nations make clear a two-state solution and negotiations leading to it must be consistent with international law. Negotiations, Judge Arnold Khassani of this court observed in the Wall case, and I quote, "are a means to an end and cannot in themselves replace that end," end of quote. He continued to say that the discharge of fundamental international obligations cannot be made conditional upon negotiations. In this regard, the court's advisory opinion in these proceedings will be most important. Far from impeding negotiations in the achievement of a just and lasting two states, the court's advisory opinion will further assist such efforts by making it possible for the parties to make progress on the sound basis of international law and international legitimacy. Mr. President, members of the court, I now turn to more technical legal arguments of my submissions. The court has heard various competing submissions this week with respect to question B of the request. But there can be little doubt as to the central importance of three matters. First, the role of the rules on the use of force in governing the unlawfulness of a given occupation itself. Second, the series of General Assembly and Security Council resolutions that have consistently and expressly called for Israel's withdrawal and referred to the inadmissibility of the acquisition of territory by war, which is a corollary of those rules. Third, the court's advisory opinion on Namibia is a helpful reference point for the court. Pakistan hopes to assist the court by suggesting a slightly different way of looking at things, which leads to the conclusion that Israel's occupation is unlawful and unlawfulness must have consequences. In this respect, Pakistan considers that a useful touchstone for the court is the general principle that no state can benefit from its own wrong. As Sir Gerald Fitzmaurice explained, and I quote, "The general principle is that states cannot profit from their own wrong, and similarly that rights and benefits cannot be derived from wrongdoing. This admits of no doubt. It is a wide general principle having many diverse applications under international law. Of course, these principles apply not merely as regards treaty obligations, but to general international law obligations also."